Oyez, oyez, oyez. The Honorable Court of Appeals for the Fourth District of Texas is now open to pursue its call.
You may be seated. I was about to say good morning, but I will say good afternoon. I will be presiding over this afternoon's oral argument. And my colleagues who are here with me are Justice Brissett to my right and Justice Spears to my left, and we welcome you. Before I take announcements, I do want to remind you that we are live streaming this, so please be very careful not to mention any minors by name, okay? I'm going to call the case at this time, 0424 00727 CR, Wesley Henderson versus the state of Texas. I'll take announcements.
Good afternoon, Justices. My name is John Gilmore, here with Ron Wilkins. We're present, ready to proceed.
Thank you.
Plain Nelson for the state of Texas, and we're ready.
Very well. Each side will have 20 minutes, and then Mr. Gilmore, you will have 10 minutes for rebuttal.
Perfect.
All right, let's proceed.
May it please the court, Justice Rios, Justice Brissett, Justice Spears, Mr. Nelson. My name is John Gilmore, and I, along with Ronnie Wilkins, represent Wesley Henderson. There are 3 issues on appeal, and I'd like to start with issue 3, as the facts and the arguments in this issue overlap with issues 1 and 2. Henderson's due process rights were violated when the state utilized false and misleading testimony from the Article 38-37 witness before the judge, along with that same testimony before the jury. The state also didn't attempt to correct that same false and misleading testimony. To give important context and background, 2 days after Henderson filed for divorce against his wife, Henderson was accused of continuous sexual assault of his step-granddaughter, CG. 6 months later, another different stepdaughter, AF, made an outcry to a counselor where she wrote a letter that suggested that Henderson abused her, without detail of that abuse. In that handwritten letter, AF noted that Henderson, quote, would not penetrate me. That's Defense Exhibit 10. It's included in Volume 8 of the reporter's record at page 78. This letter was given to law enforcement, and as a result, AF then went to ChildSafe for a forensic interview. At that forensic interview, she is silent and again does not detail any abuse. Because her first letter didn't detail abuse, and that first forensic interview didn't provide any detail of the abuse, Henderson wasn't immediately charged. However, at this time, Henderson was already arrested for the allegations made by CG, the other step-granddaughter. Because that first forensic interview was not fruitful for the state, 21 months later, AF then goes in for a second forensic interview. In that second forensic interview, AF gives a drastically different version of events than the ones that are contained in her letter and the ones that were contained in that first forensic interview. And keep in mind, at this time, AF was 15 years old, and this forensic interview was conducted in anticipation of Henderson's trial for the allegations from CG. That second forensic interview led to AF, on her own, detailing a graphic allegation that Henderson walked into a restroom, grabbed her, laid her on the bed, pulled her clothes off, made her touch him. He then allegedly opened her legs and then raped her with his penis. The state presented those extraordinary allegations before a separate grand jury, and Henderson was indicted for those same exact allegations that she made in that second forensic interview. It was a 5-count indictment. 6 months after that indictment, Henderson stood trial for the allegations from CG, the original step-granddaughter that made the allegations. At that trial, the state then brought in AF to testify about the alleged extraneous sex offense testimony through Article 38-37. The testimony elicited from AF by the state on direct, interestingly, did not include most of the information contained in that second forensic interview. When cross-examined about those statements at that second forensic interview, AF claimed to not remember them, despite her making them just months prior to trial. The state didn't ask any clarifying questions on redirect about that second forensic interview. AF's testimony before the court at the 38-37 hearing left a misleading and false impression to the trial court, and that same testimony was then presented before the jury and also left that misleading and false impression.
What was the misleading and false impression?
The misleading impression was that she didn't make those statements just months prior about this elaborate rape that Henderson allegedly had done to her.
Because she said she didn't remember.
Correct. That's what she had testified to on cross-examination. And the fact finders at that point, they couldn't make any credibility determination. The judge couldn't make that credibility determination, and the jury couldn't regarding that alleged extraneous sex offense testimony. Now, going through the constitutional error analysis regarding the state's reliance on false testimony, the first prong to consider is whether or not that testimony was in fact false. A lot of that framework for this analysis comes from habeas cases from the Court of Criminal Appeals. However, this court, the Fourth Court, actually issued an opinion in 2023 that addresses these same factors. It's Cantu, C-A-N-T-U versus State, and it's 678 Southwest 3rd 331. And of course, that was back in 2023, and I believe the state and I discussed that as well prior to getting started. As this court knows, a conviction procured through the use of false testimony is a denial of the due process that's guaranteed by the state and federal constitution.
But who determines whether it's false? Because clearly this is a situation where either she had false statements in the interview or false testimony at trial, but isn't that the fact finder at trial's determination as to whether her testimony is credible? Are we allowed to determine on our own that her testimony was false at trial?
Yes, Your Honor, and I believe you are pursuant to all of the habeas cases that detail this and pursuant to Cantu versus State. Our position here is that the trial court couldn't make a credibility determination because the state didn't correct the false impression that AF's testimony left on the court. The state didn't say that she in fact made these statements, and now she's changing her version of events. The fact finder couldn't make that determination.
It wasn't their presentation of what she actually said in this interview?
There was some cross-examination, and when she responded on cross, she merely said, "I don't remember."
And there was no independent evidence of what happened in that interview?
There is a transcript from the forensic interview, which was recorded from a camera at ChildSafe. That transcript was filed in a bill of exceptions that is in a supplemental clerk's record, and the transcript is sworn by a local court reporter as well.
So I'll go back to my questions. Let's assume that I haven't specifically seen that transcript. So assume we look at that transcript and her testimony is contrary. She made certain statements in the interview and certain statements under oath at trial. What does Cantu say about our ability to determine whether the trial testimony was false or the statements in the interview were false? I've always assumed that the fact finder is the sole arbiter of credibility and the weight to be given the evidence.
Yes. Cantu actually talks about it being the state's duty to correct that false and misleading impression. And when the state doesn't abide by that duty, it's a due process violation. Because the trial court wasn't able, as the fact finder, to even admit AF's testimony through Article 38-37, that false impression prevented the trial court from making that
Okay, I
determination.
think I'm good. I'm understanding your argument. You're not saying that we have to decide whether her trial testimony was false about whether there was penetration. You're saying that her statements about whether she said it before, if those were false, that may be error enough.
That's correct.
Okay.
And it's all about whether it leaves a false impression on the trial court. And in Ex parte Gauramani, which is cited in the brief, it's noted that it's enough that the prosecutor should have recognized the misleading nature of the testimony. Good faith and bad faith from the state, it doesn't matter. It's not important to the analysis here. But Cantu also talks about the state's passive use of false and misleading testimony, equating to a due process violation. And that testimony, it doesn't have to be perjurious to be a due process violation. It's sufficient if the witness's testimony gives the trier of fact a false impression. And the purpose is to ensure that a defendant is convicted on truthful testimony.
And you're saying the jury did not get the evidence that she actually did say something different in an interview?
That's correct. The only evidence that they had was her saying on cross-examination, "I don't remember." And that false impression is what it is that we're looking at. AF was cross-examined about that second forensic interview that took place just months prior to trial. She claimed she didn't remember her sharing those graphic details about an elaborate rape, along with other important details that actually contradicted the state's other witnesses and their theory of the case. An example of those statements that she made in the second forensic interview include that AF and CG, both step-granddaughters, met about the allegations prior to AF making that outcry. On direct, AF and CG supposedly only met about the allegations after AF's outcry. It could be where CG and AF discussed their statements together. The statement made at the second forensic interview about a detailed and brutal rape. On direct, AF didn't mention this at all. The state didn't bring it up in their direct examination. On cross, when confronted with it, she denied remembering making that statement and then denied it altogether. At the second forensic interview, AF detailed penile penetration. AF, again, didn't remember making that statement just months ago at that second forensic interview. AF's original letter, Defense Exhibit 10, that said he would not penetrate me, directly refuted that. When confronted about that letter, she didn't remember writing it. She denied it. And then when showed the letter, she remembered it after seeing her handwriting, but then didn't remember what she said in it. AF also detailed a time at that second forensic interview when she claimed that Henderson made her touch his penis. On direct, she said, "I never touched him." On cross, she said, "I never touched him." And then she said, "I don't remember saying that." These statements were drastically different than what she had testified to in open court before the judge at the 3837 hearing and before the jury.
So your argument is really that the due process violation comes into play because the fact finder, which is the sole arbiter of credibility, did not have the information necessary to make a credibility determination.
That's correct.
Okay.
And the state did nothing to ensure that the fact finder could weigh on credibility and made an admission without having the benefit of knowing that she did in fact make those statements beforehand. Those statements, they're not just mere inconsistencies or mere discrepancies like a lot of the habeas cases talk about. These are drastically different versions of events. They left false impressions on the jury. They left the false impression that AF's story was maintained and that it was consistent from its inception when she wrote that letter that said he would not penetrate me. It left the false impression that her letter was consistent with all of her allegations against Henderson. It's a false impression that AF did not just say months prior that she was brutally raped by Henderson. Left the false impression that AF came up with this allegation by herself and didn't compare it to anybody else. The false impression that AF and CG's allegations were always substantially similar. This left a false impression on her credibility. And all of these impressions go directly to her credibility. Had the state fulfilled their duty and corrected these false impressions, the court would have been made aware that trial counsel's questions on cross-examination were not just made from whole cloth, but were directly taken from AF's own statements. Neither the judge nor the jury was able to hear AF's misleading impressions because she just said, "I don't remember."
And you're saying the matter was preserved and a bill of review was filed?
A bill of exceptions,
Bill of
Your Honor.
exception,
Yeah.
sorry.
Yes, it
Yeah.
was, and it's contained in the supplemental clerk's record. And I believe it was filed before this court on March 18th, 2025. Now, the state's knowledge of falsity is also something to consider. Though the state's knowledge isn't all telling, it is a factor according to Ex parte Garamani. And so the question then becomes, did the state know that this testimony was false? And I'm going to say yes, absolutely. They had AF's first letter. They had her police report, which detailed the information contained in her first letter. They had her first forensic interview, and they had her second forensic interview. All of it was in their possession. They admitted to having it at the 38-37 hearing when they argued to admit this testimony. Trial counsel had to schedule meetings with the district attorney's office in this building because that's the only place they could view those videos because it's in their possession. The state then, importantly, presented AF's case to a grand jury using those second forensic interview allegations, not the allegations contained in the first forensic interview and not in the letter. And Henderson was indicted on those allegations that included a full-blown rape and penetration. They absolutely knew that they had this. Compounded on the fact that the state even questioned AF about going into a second forensic interview without addressing what she said, without addressing the drastically changed version of events. This court in
Was he
Kansas,
indicted before the trial?
he was just about 6 months before. This court has said, quote, "It matters not whether the falsity concerns the accused's guilt or the witness's credibility. A lie is a lie, no matter what its subject, and if it is any way relevant to the case, the district attorney has the responsibility and duty to correct what it knows to be false."
So
and
I want to make sure I understand this. How close in time was the indictment on AF's second interview prior to trial?
It was about 6 months prior to Henderson's standing trial for CG's case.
So 6 months prior to trial, they indicted Henderson based upon the testimony that at trial she said was not right.
That she did not remember,
Okay.
that she did not remember making.
You just quoted Cantu for us?
That was Cantu, and it's
What
at
were the
jump.
facts in Cantu?
Uh,
A lie is a lie.
Yes, Cantu, if I remember correctly, included the information, I believe it was about a cut. And I can address that on rebuttal if that's okay. My briefs are over there on it. But Cantu did have a similar framework, and the analogy to the framework is what's important here.
But does it matter that she said she didn't remember versus it wasn't true?
Absolutely. It left a false impression on the judge when determining whether this testimony should have been admitted. That takes us to the next prong, falsity. I believe falsity has been argued. Now the next prong is materiality. It's a constitutional error analysis, and the knowing use of false testimony violates due process when there is a reasonable likelihood that the false testimony affected the outcome. In short, that means that the false testimony must be material. And that reasonable likelihood standard is equivalent to the standard of constitutional error, which requires the beneficiary of the constitutional error, in this instance, the state, to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict obtained. Importantly, this standard is more stringent, which means it's more likely to result in a finding of error than the standard applied in Brady violations when the state fails to provide exculpatory information and in violations of the Michael Morton Act, 3914. The state, in their brief, they rely solely on ex parte Weinstein to suggest that AF's false and misleading testimony wasn't material and therefore not a due process violation. Distinguishing Weinstein, the state there had actually utilized false information about whether or not a witness had experienced hallucinations. The witness said no. The state had evidence that showed that he did. But the Court of Criminal Appeals had indicated that this witness had so much other impeaching evidence, so much other information that rendered that falsity not material. They had even labeled this individual as a professional crook. He had a motive to testify a particular way. He had sent multiple letters. That witness was cross-examined on it. They called it a plethora of impeaching evidence. Unlike in Weinstein, there's not a plethora of impeaching evidence here. AF was 15 years old at the time of trial. She denied making the statements that she had clearly made to law enforcement just months prior. These are not just mere discrepancies or inconsistencies, but very drastic changes to her testimony, and drastically different from the version that she had just said at the 38-37 hearing and before the jury.
You
And
have
in
a
that,
minute and a half left.
yes, Your Honor. And in that separate case, discovery had not yet been completed as well. Of course, it's material because the only testimony elicited from AF by the state conveniently only matched CG's testimony. That second forensic interview did not. Her statements made in that second forensic interview did not. At a glance, looking at the state's brief, it also tells the court how material this was for the state to have AF's testimony. The state argued strongly about the probative value of AF's testimony, that AF and CG's stories were substantially similar and that they mirrored each other. Of course, it gave the state the argument that lightning doesn't strike twice in the same place. This must be true. This was huge for the state's case. And again, the judge and the jury were not afforded the opportunity to hear AF's drastically different versions of events, so they couldn't make that credibility determination. The fact finder couldn't make a credibility determination accurately because the state did not say the witness actually made the statements and did nothing to correct that testimony. This is more than a reasonable likelihood that AF's false and misleading testimony affected the outcome of Henderson's trial. Thank you.
Thank you. Thank you for those 3 seconds back. Yeah, you may come.
May it please the court, Mr. Gilmore. So first I want to start by taking a step back and looking at this just very broad picture. So when you review the false testimony case law, you're going to find that almost all of it deals with writs. And those writs, they're going to come really in 2 main varieties. Most of those are going to be cases where the false testimony is discovered after the fact, and that false testimony is something that, or rather that new evidence is something that directly contradicts some of the evidence that was presented at trial. Or you'll find another variety where there are cases involving evidence that was not known to defense that's discovered after the fact. And so they're going to file a writ based on that, saying this new evidence demonstrates that the prior testimony or evidence was false. But it's a rare occasion that you get a case on direct appeal. And I think it's an even rarer occasion, nor can I find one specifically, involving evidence that's known, evidence that witness is actually specifically impeached upon, and then takes that further leap to say, well, the state should have done this or that. So specifically, I think a couple of the things suggested in counsel's briefs is the state should have played her forensic interview to see whether or not she actually remembers. But I don't think that there's any case that actually specifically suggests that we do that, nor do I think it would be consistent with the case law or the due process considerations.
But if the state
So-
knows that a witness is testifying to something that's dramatically different than other statements that were given, what duty does the state have?
So the state does have a duty to correct false testimony, and that would be whether it's knowingly false or even whether it's unknowingly false. And I believe that was the Garamendi case. I may be saying it wrong, but the state does have the duty to correct that evidence, whether it's in its case in chief or whether it's in another witness that utters it. So what I'll do here is I think it's important that the court looks very specifically at what the actual statements are, because as the case law says, there has to be some kind of definitive or highly persuasive evidence of the falsity. And that's from the cases cited in our brief. This one is Ukwachu, and I'm absolutely butchering that name. I'm sure of it. So I apologize. But the citation there is 613 Southwest 3rd. Here I have it at a pen site of 156. So what it says is the Court of Criminal Appeals has repeatedly indicated the proper inquiry is whether the particular testimony taken as a whole gives a jury a false impression. And that testimony should be definitive or highly persuasive, or rather that evidence should be definitive or highly persuasive. So we can't just look at a couple of statements that she makes. We need to be looking at her testimony as a whole. And so when we jump into her testimony as a whole, I think there's also a few important things to consider. So one is, as counsel pointed out, a lot of what she says is when she's asked specific questions about that second forensic interview. A lot of it is she's going to say that she doesn't remember. But I also don't know of any case that suggests a failure to remember something is something that's definitively false. I also don't know how you can prove someone's lack of a memory is false specifically. So I think that's something important to consider there. And then as far as her making varied statements to police or in her first forensic interview or in her second forensic interview, so she is actually confronted with some of her statements by counsel, and she actually does acknowledge saying some of them. So for example, one of the instances cited in our briefs is dealing with the last time this happened. And so in her second at trial, she's going to say that the last time something happened was her 12th birthday. And so defense counsel cross-examines her on that because she also says that she told police the last time something happened was spring break of 2020. And I'll also note too, her birthday is May of 2008. So her birthday versus spring break, I think those are two differences that are reconcilable. But in any event, those discrepancies are out in front of the jury. And so Cantu was an important case along those lines that was pointed out previously. So Cantu has a really good line in there that I think is very important for this court to consider. And keep in mind, this was just this court 2 years ago. And it says that discrepancies in testimony alone do not establish falsity. And so in Cantu, what happened was the victim got up and she testified during the state's case in chief that she went to the hospital and that she had a cut because the defendant there had cut her. And the state asked a couple of follow-up questions, and that evidence was directly contradicted by what a nurse came in and said the next day, essentially that it was caused by a perennial defect. And so what this court in Cantu went on to say is that discrepancies alone do not establish falsity. And so it's going to cite a lot of those cases that we've talked about in our brief. So this is a case where both the trial court and the jury are aware of a number of those discrepancies, and they're able to consider which of those, if any, they believe are true. And I think another point that's important is we're talking about variances in testimony here and here, but we're really not talking about the thrust of what her testimony is. So most of her testimony is going to be that the defendant, Mr. Henderson, repeatedly used his hand to touch her vagina. And I don't think there's any kind of claim that her testimony at trial on that matter was false, specifically that it's contradicted by what she says in her second forensic interview. Specifically, I believe she's consistent in that regard. We're talking about her providing different statements on edges, if you will.
Well, whether she was penetrated is not on the edge of a continuous sexual abuse claim.
And so my recollection of what she says specifically is that she doesn't recall. And I believe that the trial court actually specifically noted that because that occurs at the end of an exchange. So one point on that, the state did not ask about the penile penetration, or rather penetration with his penis in their case in chief. So the defense is going to do that on their cross-examination. And they'll ask them a series of questions. And more or less what she's responding each time is, I don't remember that, or I don't remember that statement. And then at the end of that, the trial court actually, I think, notes the ambiguity because the trial court says, make sure that you're clarifying whether or not that we're talking about the statement or something that actually occurred. So I think that her answer on that matter is a little bit ambiguous. So I'm not exactly sure what the state was expected to go on and correct. I don't think that there's anything that suggests that means that we have to go and play her forensic interview to see whether or not she remembers it or not. I think that her testimony alone is clear that she doesn't remember it. And I don't see how that lack of memory can be proven false. So before getting to all this, though, the court shouldn't even address any of this because there's a matter of preservation. So in this court in Shaw, it's a case that I've cited in my brief, but just in case, I can give you the citation too. It's an unpublished case. It's from 2018, but the Westlaw citation is 2018 WL 24184439. So this court there explicitly stated a defendant must object to the false testimony of a witness to preserve the issue for appellate review. So we have a case where defense very clearly launched an objection under 3837 and very clearly launched an objection under Rule 403. They have a hearing outside the presence of that jury based on their motion, as well as based on some live testimony. But nowhere in their brief or in their argument do they clearly indicate to the judge that that evidence was false testimony and should be excluded under the due process clause. Now, I think in the reply brief, they point out that they do use the word due process, but it's clear from the context they're talking about due process in the terms of notice provided from that other accusation, not about false testimony under the due process clause. That's a very, very specific claim. And so I think to give a good analogy that this court has probably seen time and time again, if someone makes a hearsay objection, that hearsay objection is not going to preserve, for example, a confrontation clause violation. Those are two very specific claims, and this is something where there needed to be a specific objection to that. And it's clear when you read the record, there's nothing that indicates the state understood that specific objection or that the trial court understood that specific objection. They very clearly understand the 403 and the 3837 objections, but not the false
So
testimony.
why wasn't it allowed in as impeachment if it goes directly against something she testified at trial?
Say that question again.
Why wasn't the transcript allowed to, why weren't they allowed to impeach her on it?
Well, I think they could have. And I think that they do impeach her, but I don't think that anybody actually goes to the extent of taking that transcript to her. And so what I was suggesting along those lines is I don't think that there's a case that says you have to do that for
So they did a bill of exception with the transcript, but they never asked to use the transcript in her cross-examination?
I don't believe anybody ever approached her with the transcript of that second forensic interview to ask her about it, the state or defense. So along the preservation lines as well. So the first time that specific argument is launched is in the motion for new trial. But that motion for new trial, importantly, was never actually, there was no affirmative action taken on that to get that hearing. That was filed. There's no indication that the trial court even knew about that. And so eventually that motion gets overruled by operation of law. So there's nothing in the record, either at trial or afterwards, that shows the trial court actually understood that objection. And so I think this court, in line with Shaw, in line with its prior precedent, should just resolve this issue on preservation grounds alone. And I think here this is really important because if this objection had been brought to the court's attention when that testimony occurred, at that point, he has a number of other remedies that he could go to. He could have gone, which I don't think he would have gone this way, but he could have said, you know, I agree with you when you're talking about penetration, so I'm going to exclude anything about that. And he could have left in the bulk of her testimony, which was about him touching her, using his hands, touching her vagina. So he could have said that. He could have said, you can't talk about that. Or if the testimony occurred.
Earlier, you mentioned the 613 Southwest third case. I don't know, you gave me a name, about the fact that we aren't supposed to take individual statements. You're supposed to look at the testimony as a whole. So if the jury was given all of the information and from that concluded that she brought forth several different statements, several different accounts of the incident, and therefore they didn't believe her, because it would throw credibility issue across her entire testimony, not just part of it, right?
Sure. And that's possible. So something that's very important along those lines is they're given a very specific instruction. And that instruction says you can only consider this testimony if you believe that it was an offense beyond a reasonable doubt. So in fact, we don't know if they do consider it or don't consider it. I would presume that they considered it, but we also know that juries are expected to follow instructions, or they're presumed to follow instructions. So if they're properly instructed, they're going to hear the discrepancies in her testimony. They're going to hear the fact that she can't recall a number of those things, and they can consider that as it pertains to credibility. Because I think really what we're talking about is a credibility issue. And I think that there was ample evidence along those lines for them to argue. So that's
You're saying
going
they
back to Weinstein.
effectively impeached her on other grounds.
Exactly. So the idea that the state would have to then take a step further and present them with their second forensic interview, I just don't think that's consistent with the case law that the state has to take very specific steps. I think that's the suggestion. And I just don't think that there's anything that suggests that in the case law.
So you're saying when he brought up the Weinstein case earlier, Weinstein, you're saying it's more similar to that.
I think so. And so basically Weinstein suggests that when you have all that credibility evidence out in front of the jury, it's not going to be material. So I guess that does give me a good opportunity to jump briefly into materiality. So to be clear, her evidence absolutely is, or sorry, her testimony is absolutely important evidence, right? Under 3837, that evidence can be used for any purpose, including including propensity evidence. What the case law suggests, though, is that materiality is just about the false statements, right? So if we assume that her testimony is false, it's just, are those specific statements material? And I don't think it is. And that's going along the same lines because they had that evidence to consider. So like I said, most of what she was describing, most of what she's asked about the second forensic interview, as far as the time that I'll call it the rape incident, just because I think it's the easiest way to refer to it. Most of what she's going to say is just that she doesn't remember it. And I think her answers at the end of it, they're just ambiguous. I don't think it's clear exactly what she's talking about. And then as far as the last time that occurred, the jury heard about that because she acknowledges what she told to police officers. And she also has a testimony that she said on the stand. As far as what she knew about CG, she also says during her testimony on several occasions that part of the reason she came forward was because she knew that because she knew that CG had come forward. So I think that's really something that they're able to consider. And then the last thing that I remember mentioned was about him making her touch his body. So my recollection there from the second forensic interview is the only place that's mentioned is in the context of the rape allegation. The record will reflect exactly what was said, but that's my recollection of where that occurs. And one, I think her answers at trial are just kind of unclear. The question she was asked is, did he ever have you touch parts of his body? And she just says no. I just think it's a little bit vague. But in any event, she also just specifically says she doesn't remember that incident. Unless there are any further questions, I think I've touched on just about everything that I need to. Does this court have any questions for me?
I don't have any.
Okay, well, I will give the rest of my time back to the court. Thank you very much.
Thank you. Thank you for, you gave us 3 minutes back. All right, Mr. Gilmore,
I'll try and be
10 minutes for rebuttal.
just as brief, Your Honors. Justice Rios, I promised you I would tell you about it. Cantu, I think the state did a good job of explaining the facts. It was involving a cut. There were 2 witnesses that said that the cut was a product of abuse. A sane nurse then said, no, that cut was a defect, a birth defect. It had been there. So it was a cut versus a laceration is how they describe it. And this court had classified that as a discrepancy in testimony. And because it was a discrepancy, it wasn't false. And interestingly, that nurse was present to provide a disputed statement. We don't have that here. We don't have dispute, or we don't have the ability to have another witness come in and say that what she said was incorrect at that second forensic interview. So Cantu is just a little bit short of this full-blown analysis that we have here for Henderson.
Anything that, and Justice Brissett touched on this earlier, anything precluding the defense from bringing up the previous
There was nothing
transcripts or what the court didn't consider and what the jury didn't hear?
that's an excellent question, and there was nothing precluding the defense from doing so. But I would imagine it's very difficult to cross-examine somebody when their only answer is, I don't remember. to something that had just occurred, that came out of their mouth just months prior.
But
And-
just on the fact, if she says there was no penetration and you have a statement by that she said that there was penetration, it doesn't matter that she said she doesn't remember. You could still impeach her.
She could have been impeached. That's correct.
And so how does that not affect the preservation issue?
The preservation issue is a little bit different, and I'll say that it is the state's duty to correct her false and misleading testimony.
But it's your duty to preserve error. So that's what I'm asking for.
Correct.
If the defense didn't seek to impeach it and later did a bill of exception, how does that affect the preservation?
Well, I think preservation was argued immediately after the witness made these statements. As the state had said, additionally, when resolving questions of preservation, the court must consider arguments not in isolation, but instead look to the context. And so in the context here, which is very important, this issue was preserved because it was objected to immediately after the 3837 hearing, before the trial court judge made their ruling on whether or not this testimony should have been admissible. That citation, it's in the clerk's record in the form of a motion to exclude, which detailed this. And it's also in the reporter's record, volume 4, pages 42 through 47. There is a 5-page argument by trial counsel that is contemporaneous, that's prior to the court making its ruling. Trial counsel noted that AF's testimony conflicted with her statements in the state's possession. AF's testimony was to mislead the jury, which was argued at that hearing as well, that it would unfairly prejudice Henderson, and that, of course, it would violate his constitutional rights. And the basis of due process was objected to. The basis of compulsory process was objected to, and the right to a fair trial. All of those things in the context happened prior to the trial court making its ruling on admissibility. And so those were preserved. It was timely, and they were argued prior to the admissibility without the court having the benefit of corrected false misrepresentations about her testimony.
So you're saying that was done after the witness was excused?
It was done after the witness was excused at the 3837 hearing outside the presence of the jury. That's correct. The state had also brought up the issue regarding highly persuasive evidence. That highly persuasive evidence, we believe, is contained within the Bill of Exceptions. That is the transcript of her first and second forensic interview, along with the police report that was from the state's possession. Interestingly, too, the testimony doesn't have to be criminally false. False impression is all that's required. It doesn't have to be perjurious as well. And with respect to materiality, there is a case that came out in 2025 out of the Supreme Court of the United States. It's Glossip, Glossip versus Oklahoma. That's 604 US 226. The relevant quote is at 248. Evidence can be material even if it goes only to the credibility of the witness. Indeed, the jury's estimate of truthfulness and reliability of a given witness may well be determinative of guilt or innocence. I believe that's very important for this court to consider regarding the materiality analysis as well.
So do you have any cases in which a witness simply said they did not remember, prompting the state to say, oh yeah, she should remember?
We do not, Your Honor.
Okay.
There hasn't been a case that we have been able to pull, including the most recent ones out of the Court of Criminal Appeals. A lot of them revolve around the false and materiality analysis. And there hasn't been a factual scenario quite like this, where there is a forensic interview that took place just months prior to trial, and the person was indicted on those prior charges and then goes to trial.
When was the second interview done?
That second interview was done approximately 6 months prior to Henderson being indicted.
So a year before trial.
Approximately,
Okay.
yes. I think about 9 months or so. Just to be safe, I would say about 9 months. You just make sure. I think the state on their period of time they had talked about the fact that no one had actually grabbed the transcript and put it in AF's face and impeached her with it. And the state also acknowledged that the state didn't do that as well. And interestingly, the cases that are cited in the brief and the cases that I cited here earlier today on my original argument note that it's not the defense attorney's duty, but it's the state's duty to correct that false testimony. And just like if a defendant gets up and commits perjury or leaves a false impression to the trial court or to the jury, the defense attorney has a duty to correct that said testimony or to withdraw from representation because we have a duty of candor to the tribunal. That didn't happen here. Your Honors, I'm going to give you hopefully 2 minutes left. Respectfully, for the previously argued reasons, unless there's any other questions or concerns that I can clarify for the court, Henderson requests that his conviction and that his sentence be reversed and that he be granted a new trial. Thank you.
Thank you very much. I thank both the state and the defense for very good oral argument. Mr. Gilmore, very good job on your first oral argument.
First one here.
Very good.
And it's been a pleasure, so thank you all.
Thank you very much. Your case is submitted and you will be notified as soon as we have an opinion for you. Thank you very much.
Thank you.
All rise.